of stay. After all, the Election Commission has also to decide in accordance with law. The result was, I mean, this is again the sad part of it. The result was the commission says, I'm not going to bother about the organization. These 39 members are majority, therefore they get the symbol. In fact, your lordship's order was misused.
We are not considering the validity of the order passed for the election.
No, I'm not asking, Malas. I'm really saying the commission said, the High Court said, Supreme Court has said no stay, therefore they have to decide.
That is to be tested in those proceedings, no?
No, that's not. But kindly see the consequences, Malas. Kindly see how we are hurt. That's why the reference, what is the scope of powers of the Election Commission in respect of determination split within the party? Malas, I'm not, your lordship's passed, Malas, rightly so, according to me, that let the commission, but the commission doesn't have to, can't disregard basic principles that you are giving symbol to a party on the strength of those 39 whose disqualifications are pending.
And that issue is pending before this.
That's pending. And I said to them, please stay your hands. They said, no, but Supreme Court has said that we have to go on. That's how the symbol is given. See that injustice caused to us. I just make the point, Malas, and not go further. And then the last thing, Malas, kindly read now paragraph 115 with me. And then I'm done, Malas.
Para?
115 of the symbols order. 15 of the symbols.
15.
Sorry.
Para 15 of 15.
Statute compilation, Malas, sorry.
Important.
Page 91.
It starts, 15 is there.
Page 91 it starts, Malas. And paragraph 15
Page 103.
is at page 103. PDF 103. Yes. 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 Says, Malas, when, lordships have it, when
Yes,
the
yes.
commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. Well, I'll just stop here. So the jurisdiction of the commission starts when there is a claim that there are rival groups within the party. And it must have evidence in its possession, information in its possession, and must be satisfied with the information that is in their possession. That they are rival groups. Now, your lordships have seen the correspondence, 21st June onwards. There is not a whisper of any rival group. Not a whisper. It's only the 39 sitting there.
So just to rephrase it, according to you, there was no information in the possession of the EC to show that there are rival groups, and it has to be satisfied.
Yes. Now, Malas, the petition.
Can you just rephrase your submission, Mr. Sibal, again on this point?
Malas, I'm saying, Malas, the jurisdiction of the commission will commence when the commission has it in its possession information on which it is satisfied that there are two rival factions within a political party.
Right. And in this case, what is the...
Now, Malas, kindly see. Therefore, in the context of this 10th schedule, Malas, now just that proposition. In the context of the 10th schedule, the only way you can get a symbol is when there are two rival factions within the party. It has nothing to do with the 10th schedule.
No, this has nothing to do with the 10th schedule.
Correct.
Right? So, Manas, there has to be a faction emerging. Take, for example, Manas, majority of the people in the 10th schedule, are with Thackeray. Let's assume all 55 are with Thackeray. Then also para 15 Manas can be invoked.
By somebody making an application.
Because 15,
didn't understand you what you're saying.
para 15 refers to the party.
That's right. So, Manas, the split has
Schedule refers to
correct. The
what you do on
split
the
has
floor
to
of
take.
the House.
I'm
Right.
agreeing, Manas. I'm saying exactly
Right.
that split has to take place within the party.
Right.
That split did not take place on 21st June or immediately thereafter. Never took place. A petition is filed on the 19th of July.
Correct. 19th of July.
Just note that, Manas.
19th of July.
19th of July.
19th July, absolutely.
Correct.
Right.
And on the 18th of July, it is alleged, what is submitted along with the petition is minutes of meetings. Minutes of meetings. Well, will my lord allow me to just place
Start.
before your lordships? Just give it to my lord, please. I will give you the copy. This is on 18th July. The matter was fixed in this court on 20th July. All petitions were to come up for directions. So from 21st of June to the 18th of July, nothing happened. No faction, no claim for faction. Just give it to my lords, please. Now, let's, on 18th of July, just kindly come to page 7 of this compilation.
What is this? Mr. Sibbal?
Oh.
Minutes of meeting of?
Minutes of the meeting.
Of Shiv Sena
Translation of the Pratinidhi Sabha. Page 7. Typed as page 7, Manoj.
Where is the Marathi start? Just, I can read the English.
Previous to that is the Marathi, Manoj.
What page?
It says on top.
It says on top, page 48.
48.
8. 3 pages before that. Or before Malas, the English version.
46.
Now, what do you have here? Your lordships may take it, there is no summons for any meeting. No venue for any meeting. No time for any meeting. No signatures obtained at the meeting. Nothing. Just note that, Malaj. No time, no place, no date is given 18 July, no summons. I suppose this is a meeting of the Pratinidhi Sabha of the Shiv Sena. So it must be known to everybody where the meeting is going to be. Summons must be sent like we sent to them. Right? What they do is they give a translation of the minutes of the Pratinidhi Sabha. And in the minutes, they show some resolutions have been passed. Minutes, as your lordship will know, is after the meeting. It can't be before the meeting. Right? Has to be after the meeting. So there is the minutes of the Pratinidhi Sabha, and there are also minutes of the Karyakarni. That your lordships will see at page 10. Again, minutes. Again, when it is held, what time is it held, where it is held, Yes, they say it happened, it is held in Bombay. I guess, Malaj, someplace in Bombay. They must have known. Now, Malaj, so 2 minutes are placed before the Election Commission. These 2 minutes.
Subsequent minutes also of what date? 27th?
27th of July. That's even more interesting. Well, just note the note 27 July and then go back to the petition, Malaj, that they filed. It's very interesting. These are the two documents that they placed, nothing more. Plus, of course, appointment of people. We're not into that. Convenience volume 2. Page, volume 2. Convenience volume 2. Yes. Kindly see page, PDF page 699. Paragraph 8. Oh, sorry. 698. Where is that? Yes. 698, Roman 626.
PDF page?
PDF page 698. This petition is filed on the 19th of July. Just mark that, Malaj. This averment is made when the petition is filed on 19th July.
Is the page number, Council?
Page number.
698, Malaj. PDF 698. Just above that, Malaj, Roman 25 at 697, the last two lines of that page, if your lordship has that.
What is this document that you pointed out?
It says, further, a meeting of the Pratidhi Sabha was convened on 18th of July. Your lordship has that sentence? Yes. Whereby the petitioner Eknath Shinde was appointed as senior leader and Shiv Sena Mukhya Neta, main leader, minutes of the meeting of the Pratidhi Sabha. So they say minutes of the meeting are there. No meeting, no place, where it was held, when it was held, who was summoned, nothing. Right. Then come to the next para. A meeting of the Rashtriya Karyakarani was also convened, whereby the Rashtriya Karyakarani has affirmed, now please note this, has affirmed the election of the petitioner as the Shiv Sena senior leader and Shiv Sena Mukhya Neta. Now this is on 19th July, and the minutes of that are 27 July. I showed that to your lordship. This petition is filed on 19th July. He says that the petitioner was elected as the senior leader and senior Mukhya Neta. The minutes are dated 27 July. This is what they filed, Manas. So 19 July, they could not have known what would happen on 27 July. And that also minutes of meeting. These are the only two documents with the commission. That's why I read paragraph 15. These are the two documents with the commission. In respect of, to prove that there are two factions arising. The second document was submitted during the course of hearing, but be that, I don't want to go into that. I'm just only interpreting 15. This is the documents in their possession, information on the basis of which Election Commission is satisfied that there are two factions within the party. So minutes of meeting. Well, that's...
Where are the minutes of meeting here in this compilation page, PDF page?
Yes, we just shown that one. Here and it's not there. That's why we...
It's not an annexure.
That's why I gave that to your lordship.
Just a symbol, but that's not an annexure to the petition. Are we right?
It's not here, Malad. That's why I gave your lordship.
No.
Where are those
What
minutes?
I'm just, let me hear, my lord.
What you have read of this para 26, para 25 refers to annexure P5, which is the minutes of the meeting of the...
We haven't put it, Malad. That's minutes.
We don't have. But the petition also does it and close it is what we are trying to understand.
Yes. That was handed over, Malad. It doesn't say. That's why we gave it to your lordship.
That is on the 27th.
Yes. So now it says 27th. This petition is filed on 29th. These are They did enclose the second one they didn't enclose, first one they've enclosed. P5 they enclosed. So, Malad, these are the two documents with the commission. Now, if you read paragraph 15, this represents two factions in the party, the minutes of meeting. That's how the election commission, Malad, got jurisdiction, according to them. And Malad, this is a final order. This is kindly just look at it. I can understand if the commission says lead evidence, I can understand, please prove your case. On this basis, a final order is passed, which is the subject matter of challenge in the other proceeding. That's how they got the symbol. So what does the governor do? What does the election commission do? And this is the evidence. And then we have to, we must ensure, we must trust that all institutional authorities function in accordance with the law. And if this kind of manipulation takes place, Malad, in the processes of institutional decision making, where we go, Malad, where we will go, I don't know. I am done, Malad. I just want to make one non-statement. I stand here not for this case. I may lose it, I may win it. That's another matter. But I stand here, Malad, for the protection of what is so close to our heart. Institutional integrity, and to ensure that constitutional processes survive. Otherwise, if your lordships endorse such a position, it will be the death knell of what we have cherished since 1950. Thank you.
Thank you. Yes, Dr. Singhvi.
Yes, I would wish to take your lordships principally to some very interesting underlying juristic principles. Because the lordship has now seen the facts for 2 days, so I'm not going to repeat. Juristic principles which should impel your lordships to decide this matter here and not consider the various options or suggestions of sending it back to the speaker. That's going to be the bulk of my argument. But Balas, I want to start with where we are ending up, because I was here the whole morning and I heard the very important question which fell from the bench, and the Honorable Chief Justice in particular, about the role of the governor. And I'm going to repeat anything. I'm going to try and give a different facet. Well, this is a very unique and a strange case. And I would say from this side, a sorry case, where lordships has double whammies and triple whammies. Let me explain how. My Lord Mullis put the question of the governor's role. And in one sentence, the question is that if your lordships if the governor found that there is something to be decided by way of unstable majorities, even if you exclude 39, why can't he go and have a trust vote, etc., or a decision on the true majorities in the confidence of the House? Well, it's the first thing when you start on that query has been perhaps not given sufficient weight. And the first thing is that your lordship's fundamental rock-solid principle of interpretation of constitution and statutes is that if intentionally a constituent assembly in its amending power of the constitution deletes something, your lordship gives full effect and scope to the intendment behind that deletion. That is well as axiomatic. It is obvious a puny well as contract or a statute, much less a constitutional amendment, where Lordship's intention is to give effect to that intention.
So para 3 has been deleted.
Now, para 3 deletion is not a small thing. There are debates, there is a SOR, the Constituent Assembly, the Constituent Parliament in its constituent capacity said, look, we must delete it. Why this case is bizarre is that there are three, at least two, circumventions of that deletion directly by high constitutional authorities. Circumvention 1 is clearly this way or that way, whether the governor can do it or not do it, the Lordship will decide separately. But clearly and specifically, the governor is acting on a presumption of a split. In whatever way he's acting. Now, as the governor, most of all is supposed to know the Constitution. All of us are supposed to know the Constitution, and ignorance of the law is no excuse, much less ignorance of the Constitution. There is no system, and I'm not talking of your Lordship's narrow question of trustworthy, non-trustworthy. There is no basis on which your Lordships can reconcile and harmonize the factual invitation and oath giving on the one hand with the legal deletion of para 3. That's my proposition. Two are irreconcilable. And that is a very major constitutional sin underlying this whole supposition and context. The second makes this even more bizarre. There is no counterpart to curiouser and curiouser. It can't be bizarre and bizarre. Well, there is a direct finding in not one but many paras of the EC order that this is a split. I'm not asking a lot, Justice Shah is right. We are not on the appeal on that. That's not the point I'm arguing. I'm on the context, Wallace. People are here going around merely on the assumption of a split, then the Lordship might as well wind up the 10th schedule, the constitutional amendment, the deletion. What's the point of it? I'll give the paras, there's more than 4 paras or 3 paras in the EC. We'll just give the paras. Yes. Now, Millets, therefore, your Lordships and those cases don't have to be given to your Lordships of elementary forms of interpretation that if I delete something, your Lordship gives effect to the deletion. I'll supply them, Millets. It's not necessary to do it. The second answer was the second Millet's response in the larger context of that query. So this is the first response. The second is, your Lordships decides cases, not that your Lordship decides the narrowest of narrow issue, your Lordship decides the whole context. But your Lordship doesn't decide beyond the context of a case. Your Lordship is very careful, otherwise the things of biter and all that come in. And your Lordship doesn't have time to spend on hypothetical questions. But let us see the context. The context of this case can be divided into broadly 2 or 3 or 4 categories. And that context makes it clear that your Lordships need not be bothered about the governor coming into the picture at all. The first phase of this context is the expedient of giving a disabling notice. I call it a disabling notice before I intend to defect. Now, that will be awaiting your Lordship's decision on Nabab. So, phase 1 or part 1 of this context is disabling notice. Your Lordship must decide in Nabab. That's the whole argument we made for 2 days. But clearly the context is that step 1. And if that is wrong, then a lot of things fall down. And that is wrong in case a Lordship doesn't agree with the literal text of Nabab. The second part is that we are also forgetting repeatedly the object of the 10th schedule. Well, as more than any other jurisprudence in this part, subject of constitutional law, are cases again and again talking of 2 things: the evil prior to 84, the object of plugging that evil, the mischief rule, and what your Lordship is doing by the 10th schedule. The third is that if your lordships accepts that the basic object of the 10th schedule is a constitutional sin being precluded or stopped or reduced, then 2-1 A or B, as the case may be, has to be decided first. It's logically prior to everything. Not only is it prior in terms of serial number, but conceptually it has to be logically prior to any decision of any kind in any case. I'm talking of concept. I'm not talking of a delay by an individual speaker. Whether the Kerala speaker will decide tomorrow, Nagaland speaker may take 6 months, a Manipur speaker will take. That's not the point. Conceptually, the logically prior decision has to be para 2, not a governor's intervention collaterally in any which way. That's the structure of the 10th schedule. And that scheme and structure must be endorsed and strengthened by your lordships. Inter alia, by not accepting any collateral incursion horizontally sideways by a governor, while that 2-1 is still pending. Other aspect of this, which has to be given a lot of weight is, apart from what we just talked about, the trust vote, people tend to forget that in almost every assembly, there is a very interesting rule. You cannot bring repetitive no confidence motions also.
6 months.
Your lordship knows 6 months. So I bring a no confidence against you, I lose it, I can't come after next week again, say I have no confidence against you. So, the next facet of this is the processes within the parliament and assembly have to be allowed to work themselves out first before external intervention. And one of the important processes is to notify a confidence or a lack of confidence. If your lordship is so careful about not even allowing repetitive bites at the apple to destabilize a government, the lordship will allow an external incursion without even a single no confidence motion. I'm not repeating, I'm giving lordship in addition the larger context. Not even an attempt. Whereas, as they say, the proof of the pudding is in the eating. If you have the confidence, move the no confidence. It's your lack of confidence which makes you not move the no confidence. Because you know how the no confidence will be met. And may the best man win. If you have the guts and the courage, do it. Whatever will happen, will happen. That's the process of democracy on the floor. Incidentally, when I've done the maths, that chart, I mean, it is not that your lordship will only ask them to show the material. We are having a preliminary objection that the governor doesn't come into it irrespective of the material, even if he has seen the material. I am now on concept, I am on juristic principle. There is no role of the governor till now, till whatever I have said, 2-1, etc., process, no confidence, no role for the governor. It's a second separate question on facts, what the governor saw, did not see, but he had no locus to see or not to see. So what's the point of going into down that path, fellows? The governor had no locus at that stage to see or not to see. It would really amount to a very strange thing where the governor would, governors are now, obviously, if you read the debates of Mr. Ambedkar and now there's a vast difference. But Governors are also creatures of political connection. The governor would say, I see a group of people here. Why are you bothered about moving a no confidence? Come to me, we will see something. There's no need for us. The assembly gets substituted. Will be circumventing and short-circuiting the entire process of a no confidence on the floor. Yes. Now, having given that answer, let me turn to my larger point on which I was really going to address your lordships. And give your lordship just bullet facets, and then I will give your lordship the material underlying it, the juristic principles as to why your lordships should deal with the matter here. Now, I understand that it is easier not to deal with it here. It is also equally possible not to deal with it here. There is a speaker. My lord has heard enough facts. So, lordship will take those facts as given. I will touch upon the facts here and there, but mostly no. In the event that the facts and the context suit your lordship's discretion on this issue, should your lordships in law juristically refer it or should you hear it is my respectful submission. There are four or five legal facets. Then I'll give your lordship the case law. The first is that there were two one negative and one positive order by this Honorable Supreme Court. That should be remembered. In whichever way it is worded, the negative, I'll call it injunction, on 27/6/2022 was that by the expedient of extending time, the speaker was effectively de facto could not pronounce on disqualification. It is nothing but an injunction in substance.
Till 12th.
Till 12th, correct. Then events took over, Then events took over, but my lord is right, till 12th. Therefore, let us look at it because the lordship is always a court of substance. We can camouflage in so many forms, but your lordship ultimately sees this in substance. It's a judicial injunctive interim relief where a speaker's future action under the 10th schedule. That is the correct way of putting it. It is a judicial interim intervention. It's a negative injunction. And the second was a positive injunction, if I may call it, or an order of 29th, allowing the trust vote to be held. So not injuncting the second day, injuncting the first day. So there is a negative judicial intervention followed by an affirmative judicial intervention. I am not making any value judgment. Your lordship would have heard it next week, 2 weeks later. Who knows, everything could have been reversed. I'm not saying that at all. I'm not saying right or wrong. But I'm saying one thing is clear, that the formation of a government, I'm making a neutral statement, I'm not allocating, is clearly the direct and inevitable result of the combination of these two orders. Lordship could have heard it next week and upheld it. So Lordship would be right. Your Lordship could have reversed it. Lordship would be wrong in the interim then. That's not the point. The point is, let us not see this case in the abstract, in an ivory tower, unrealistic approach. Let us see it in reality. We have to smell the constitutional coffee, if I may say so. The reality is this, that absent these two negative and positive orders, your lordships cannot have this consequence of a change or a new government. This will have, correctly an effect on your lordships needing to decide this year. And the second aspect, I'm only giving the legal bullets, I'll cite the case law later. The second legal aspect, the juristic principle, is the language of that order. Now, we all say it casually. Sometimes your lordship is also made to say it casually. But these are terms of art. Your lordship has used them for decades and centuries in law. And these common law terms of art have to be given effect to. Don't go to the page, just note your lordship's order on 29th read like this, one line, quote unquote. subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, unquote. That's your Lordship's order. This is my second facet. Subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, which means the whole batch of writ petitions. By then, many petitions had come. What is the meaning of this frequently used phrase? And normally the phrase doesn't come up, Alice. Your Lordship has some very, forget this case for just 1 minute. Your Lordship has some very interesting examples in building law and construction. Well, the first time your Lordships ordered demolition, the first time, not now, of a 20-story structure was almost 15 years ago. Ironically, I think the second one is also from Lucknow. Both are Lucknow examples which came here. Your Lordship had passed only subject to. Construction will go on. Ultimately, your Lordships held against. Your Lordships ordered demolition. Demolition, in that sense, with people living and concrete and mortar in the building, is much more irreversible than merely a political thicket or a scrambled political egg created from 22 to now. Now I come to what subject to means. The object of this phrase subject to are two and threefold. One is that your Lordship's speaks in rem, not just bilaterally between the parties. Your Lordship speaks to the whole system, to the whole world. And second, your Lordship is giving a fair warning that everything which is happening after this is subject to, but on your risk and cost. And thirdly, your risk and cost means all consequences, equities, vested rights, all status quos you create each day after that. Is it your risk and cost? We are warning you. Don't blame us later. That's the meaning of this, and I'll cite a case presently on that. Therefore, the moment, either your Lordship doesn't say it, the moment your Lordship says that, no one can come and plead equities, vested rights, events, scrambled egg, irreversibility, etc., etc. Because your Lordship takes into account this in advance. If your Lordship passes subject to today, it is different from passing in 2022 June. The fourth facet of law, which I will develop in a moment, is that third. I'm sorry. What is third? Third. This is now. It's called pointillism. Pointillism. It's not a bad technique. It makes it for specificity and a certain amount of clarity. It may not always be. It is liable for some intellectual property protection also.
Correct. More than anything, you will know where you are going.
Now, the third one is para 110 of Quixote, which your Lordship has seen right at the beginning of the Navam Rebia arguments, but Lordship may kindly be reminded of that. Just turn to 110 in the first compilation, PDF, page 74.
First judgment compilation.
Judgment compilation. Or basically, the very strong constitution bench injunction when the jurisprudence of 10th schedule was starting. Quixote is virtually the first. I mean, there were some cases, virtually the first, certainly the first constitution bench and the most important 10th schedule judgment at that time. They started this jurisprudence with this great warning and mandate. PDF 134 or 74? 74, the Quixote starts at 134. At 134. Para 10. Para 110. Full thing is good. Full thing is good. In view of the limited scope of judicial review, I read it?
Yes.
In view of the limited scope of judicial review, that is available on account of the finality clause in para 6. So Your Lordship gives basis for it, finality clause in para 6. And also having regard to the constitutional intendment and the status of the repository of the adjudicatory power. Speaker, Chairman, judicial review cannot be available, mark these words, cannot, Constitution bench is saying, cannot be available at a stage prior to the making of a decision by the Speaker, Chairman. And a quia timid action would not be permissible jurisdictionally, threshold, nor would interference be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings, and such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. But I'll just pause here. It has some very startling consequences. If Your Lordship reads this, it's a constitution bench. It makes only one exception. When I, the Speaker, by an interim order disqualify you, that has happened hardly ever. Well, it's happened once or twice, but it is not really happening in the 10th schedule. Maybe that will be a new technique adopted in the future. Well, I don't know. But today, well, it's hardly any case. But
You are giving the idea.
no, but Quixote gave that idea. Quixote has given the idea already. But that's why I'm saying from 92 till now, it has not happened despite Quixote's idea. I mean, it may have happened one or two cases, but hardly ever happens. Yes, Kuldeep Bishnoi case, etc. But well, in that exception apart, it is per se jurisdictionally bad. So therefore, Malus, a perceived error of the Speaker's conduct will not justify your interlocutory application. That's important. Let us assume that the Speaker is wrong. Nobody is conceding that. Let us assume that the Speaker is grievously wrong. It will not justify circumventing of a constitution bench by saying, normally we will not interfere, but here, by a matter of degree, I opine that he is grievously wrong, therefore we will interfere. Let's take an example. Your Lordship has applied that example for decades. This is not something strange at all. Quixote was, according to me, saying the obvious in a much more important category. Your Lordship has done it for lesser category. Well, as Your Lordship finds genuine problems in an election process. When an election process starts, Your Lordship finds genuine cases. My nomination rejected badly. I was stopped at the door by a guard. I couldn't enter. Somebody obstructed me. I couldn't file in time. This man is rejected on a comma, full stop, wrong ink. They are very compelling arguments. Your Lordship says, come after the election. In 99% cases, unless there's a special statute. Because you don't interdict an autonomous, self-contained scheme of a code there to let elections go on. Here, a much higher constitutional authority to allow unfettered proceeding further. There are many more examples the Lordship has. Therefore, the position which by a combination of the positive and the negative order inevitably led to the change of government possibly was also constitutionally wrong. Had Your Lordship had occasion to discuss it in the 2 weeks following that, Your Lordship would have rectified it. Today, it cannot be a bar merely because of passage of time, because this is on the face of it contrary to Your Lordship's constitution bench. And an error of the Speaker was irrelevant. In fact, he hardly had opportunity to commit many errors except perhaps as a 2-day notice. That would have been decided. I've cited, Lordship members, 2 cases I cited in the Navam Revia, where 3-day notices were sufficient. Yedurappa and, Yedurappa was the other way, was Nayak and Balasa, Patil. Srimant Patil. Three judges, 3 days, sufficient. When the rule said 7 days, I hope my Lord remembers that. In Navam Revia, I cited those cases to Your Lordship. Rule said 7 days, 3 days notice. 2-judge bench in Ravi Nayak said, okay. 2-judge bench in Yedurappa doubted it. 3-judge bench subsequently affirmed the Nayak principle, despite noting and citing Yedurappa. Then, the 4th facet is that the more important and the more general principle, but equally important, that your lordships respects co-equal organs. There's a whole other line of cases. When I come to my notes, I've cited some of them, where your lordships is very careful, because your lordship now doesn't think of an individual speaker, but of the institution, where your lordship doesn't enter into co-equal branches unless there are compelling reasons. So respect between and mutual balance between judicial and legislative organs is the other legal principle which has to be kept in mind, and all this goes towards making the non-interference principle at that interlocutory stage. Then the other facet which your lordship in case law has used is, there may be a rarest of rare exceptional situation where your lordship passes interim orders, not in this case, no case, I'm saying generally. Now I'm not going to tension you, to maintain a status quo. But your lordship is very, very sensitive and cautious and careful to create a new status quo by an interim order. Maintaining a status quo and leading to the creation of a new status quo are two different principles of law looked at and dealt with differently by case law. Here clearly a new status quo was created. The fifth principle is actus curiae. Obviously, actus curiae arise in the event that your lordship finds that I'm partially right or fully right, not otherwise. But if your lordship finds, then your lordship reverses the most intertwined situations, because the lordship never allows the act of court to do any harm. Actus curiae nemine gravabit. The sixth facet is that
Seven.
if there is
Seven.
a right made out, I'm sorry, my
Seven.
apologies.
No, 6.
Seven.
Next. Actually, I dictated these later on, so my numbering is also in A, B, C, D, E, F, G, because the main submissions are below in 1, 2, 3, so I don't have those numbers. But your lordship is right, I'll say next, your lordship will have your own numbering.
Yes.
What your lordship, I'm sorry, this is not that we are using Latin. Your lordship has warned us in recent judgments against using Latin, but these are basic principles. The other one is ubi ius ibi remedium. If your lordship finds that I have a right, in this case a constitutional right, made out by all this which we have been arguing, then at the end of that right to say that I am remediless. The remedy which is effective and real is only a reversal of the status quo ante, as would stand immediately prior to the consequence of those two orders in June. The consequence being the change of status quo on 4th July? 4th June. 30th June is the swearing. 30th June is the swearing. I'm sorry, not 4th July, 30th June. So it must be a status quo ante. In the event that your lordship applies the principle, obviously ibi remedium doesn't arise unless there is ibi use. If I don't have the use, I don't have the remedium. But on the assumption that I have, then your lordship will not be told it's a fait accompli.
So what would then be the consequence, Dr. Singhvi? What does the court then, logically, what would be the directions of the court?
Well, logically, the direction is that that particular act of swearing in is wrong, and your lordship will have the whole thing done again. Your lordship could then, to give a lordship, your lordship give a substantive answer.
Yes. What will be the substantive directions then?
Yeah. Now, I am giving your lordship a substantive direction. Of course, I will develop the law which is yet to come. In the event that that is correct, and that is the majesty of the law, that is what your lordship means when your lordship demolishes 25-floor buildings. And the message goes that your lordship is ultimately establishing the supremacy of the law. Supremacy of law is by no other means except by result, by actual de facto on the ground result. The rest remains paper and words. It would be, a reversal of that oath. I'm being very formal and constitutionally proper. A direction.
Oath is on 3rd.
No, I thought 3rd, it's 30th. I also thought 3rd, that's why I said 3rd. Apparently it's on 30th.
Because on 29th.
That's right.
Night he
That's
resigned.
correct. That's correct.
Of course, Thackeray
That's
resigned on 29th evening.
That's correct. Doesn't matter 3rd or 30th, but reversal of the day before that. Second, for the purity of the process, your lordship will, there is still a deputy speaker, should decide what he would have decided but for lordship's injunction. Because your lordship is now counting the status quo ante on the but for test. But for these two orders, what would have happened? Obviously, only this would have happened. There would have been no swearing in and there would be a decision. Plus, it sounds sometimes difficult, but imagine.
So far as
Kindly note.
Dr. Singhvi.
Yes.
When you are on the interim injunction, not granting interim injunction on 29th and to see that the status quo ante is maintained, it was only with respect to the floor test on 30th.
And he resigned. That's what, and Lordship is asking. No,
1 minute. You can read the. On 30th, on 29th, he resigned. The order dated 29th, not granting injunction, was very clear that the floor test on so and so would be subject to the floor test on 30th would be subject to the ultimate outcome. Correct? Now, in that case, correct, raise the question of status quo ante.
Yes,
correct.
I'm
on
very grateful.
On the basis of the 29th injunction or not granting injunction.
I'm very grateful for a query. Your Lordship was put it in a different way earlier. I must answer it again. It's very opportune at this moment. There are two answers. One answer I gave 3 minutes ago, your Lordship's court is a court of substance. Always, not of form. Let me develop it. I'm answering only my Lord's query. Paramount is substance, the heart of the matter. It is true that on that day, on 29, nobody would know what would politically happen on 30th. And it is true that the technical word used is trust vote. But what was allowed to go on was a test on the floor, which is inevitable if 39 vote against. The one and only foregone conclusion, instead of suffering the humiliation of a vote, is to give up in advance. We are in a real world. There is no arithmetic, no science, no physics, which can change the result on 30th. If these people who comprise this, so the floor, I argued the matter on 29th and the earlier dates. One of the main arguments was that the moment your Lordship permits these people to vote, we were seeking an injunction. How can there be a trust vote with a tainted, how can you have a swimming pool with some part of it tainted with poison?
No, therefore your submission seems to be.
That was not accepted.
That not granting the injunction.
Yes.
Correct? Would in fact had facilitated those 39.
No, it was an additional argument, Balus. I'm very grateful. One argument was that this trust vote is, Balus, completely unreal and futile because you have not excluded the tainted fruit.
On the other hand,
the other argument was, Balus, that if your Lordship has stayed that, stay this also. That was a more important argument.
The flip side would have been that
stay both.
Dr. Singhvi, if you had faced the trust vote,
yes,
on the 30th,
yes,
these are open. There is an open vote.
Yes,
right? Because you have to, because that's the whole principle of the whip. if you had faced the trust vote and lost, then it would have been clear as to whether these 39 people made a difference, how they voted, and whether that made a difference to the ultimate trust vote.
So we did not do it. It's a given fact. I can't change
Right,
it.
right.
Right, Wallace?
Right.
I'm answering. Wallace, let me answer this also.
And the voting pattern would then determine as to whether these 39 who are otherwise facing disqualification motions, whether they affected the trust vote or otherwise.
I appreciate. No.
If you had lost the trust vote only because of these 39, then you absolutely got a plausible point that, look, these disqualifications, if they get disqualified, then I win the trust vote. Isn't it?
Therefore, Wallace, let me. So the first part is the conceptual.
I mean, the area is not free from doubt. The reason we are putting it to
Wallace,
you is because there is a constitutional question in our mind. That's the.
I hear your lordship loud and clear.
Yes.
Let me, because certain given facts, Wallace, we can't argue about. The fact of the matter is, nothing happened on 30th. The man did not, Wallace, go to the trust vote. No doubt about it. Now, Wallace, the first conceptual answer is, we are now, Wallace, on what I have been saying and Mr. Sibal has been saying earlier were legal errors. Whether they were or not, the lordship will decide on Wallace 22nd, 23rd orders. But the argument regarding 29th order was that either you should not have stayed that, but if you stayed that, stay both. You can't stay that and allow this vote to go on.
Right.
That's the first point to be remembered.
If you have stayed the disqualification, then stay the trust vote also.
It's very unfair and uneven and non-level. Well, if your lordship is hearing the matter next week, I believe it was on a Monday next, it was listed. Then both could have been held afterwards. The lordship, as well as in the Karnataka late night matter we did, your lordship said, not today, next morning, it will happen at so and so time. The reverse is also true. Don't have it there, have it after 4 days.
So your argument to therefore restate your argument, what you are really arguing is this, that once you stayed effectively the speaker from deciding the disqualification petition, then you should have stayed the trust vote also, because one was linked to the other at the least.
The word linked, inextricably intertwined, absolutely. And that is the answer, the first answer on the conceptual query raised by my Lord Justice Shah.
No doubt.
It is true. Technically, one is a trust vote, one is a floor test, one is nobody comes.
But you're right. I mean, because
substance
at the trust vote, those people were going to vote.
So that's the first. Now, second, no, I will go further. Since the lordship has put a different question.
But still, Dr. Singh, the problem still in your path. I mean, the problem still arises.
It would have been shown on that.
The consequence of these 39 would have really.
No. So let me show. Therefore, now that will not affect this question. Let me be conceptually clear. Yeah. My Lord's query is right, but that will not affect the question I'm arguing now. That will affect, as in when your lordship takes up the disqualification and says that we find that no disqualification occurs because we don't have sufficient proof to disqualify. That's all that will mean, Maharaj. It will only mean that I have insufficient evidence. And I'll tell lordship why lordship.
Nabam says, applying Nabam here, the speaker could not have decided. I mean, I'm not putting that against you, but I'm just trying to analyze.
As the principle today stands.
As the principle today stands.
Correct.
Nabam says that where a motion for the removal of the speaker is pending, he cannot decide the issue of disqualification. You say refer Nabam to a larger bench. But suppose you take this, that well, these 39, that Nabam therefore should not be construed to prevent the speaker from deciding disqualification.
Yes.
And these 39 were therefore liable to be excluded because the speaker would have been justified in hearing the disqualification, notwithstanding the pendency of the motion to remove him, that the speaker would have disqualified these 39 because, as Mr. Sibal said, it's a per se disqualification. It's a clear split. What is the ultimate consequence? That these 39 have to be taken out of reckoning on the trust vote which takes place.
My lord is back to the chart figure.
Which these 39 have to be
Thomas,
taken out
we
of
have answered
reckoning.
the governor point. Lordship is not coming to the governor. Governor is constitutionally barred. I'll deal with the chart in a minute. Well, today, can your lordships proceed on hypothesis upon hypothesis? What would have happened had this happened? But I will satisfy that conscience also. Well, first part of my Lord Chief Justice
Did you
was
not really
the governor could have acted on that.
Did you not preclude a consideration of this argument by your own
Therefore, let me
failure
answer
to
all.
test the
I'm very grateful
face
for
the legislative assembly?
So there are 2 or 3 answers.
Because also, I'll tell you why, and we'll rise then and we can reflect on
yes.
this at lunch. Because today, what you are really asking for, and we're not saying that you are wrong in asking for it, because first principle, the court said subject to the outcome. So therefore, we have to now treat it, if we come to the conclusion that you are right, then ignore all outcomes.
And
which
my
are-
lords have done it twice in
Fair
10
enough.
scheduled cases of big moment. Twice.
Fair enough. But before a constitutional court does that, namely to set back a status quo ante constitutionally, we must be in a position to say that, well, there is an arguable outcome which would matter.
Absolutely.
Which would make a difference.
Absolutely.
If whether there would be a difference or not is really foreclosed by virtue of the fact that you prevented that difference from emerging before the
Why
court.
it is not foreclosed? I understand my
Let
lord.
us think on this.
I'll
We come
show you
back
my
at
lords.
lunch.
I'm deeply